We spoke last time about the impact of John Collier on the formation of federal Indian policy and the implementation of that policy. Collier's tenure was marked by a reversal of the allotment/assimilation policy of the previous decades. And it was so profound a reversal that, as we'll see, it's still with us today. But for a brief period, there was a setback in Collier's agenda, and it occurred in the years immediately following his departure from office. Collier left the Bureau of Indian Affairs in 1945, and within a few years, the focus of federal Indian policy had again returned to assimilation. So we're going to speak now about this change back in policy, which will prove fairly short-lived, at least in its most material aspects, but important nonetheless for understanding both how vulnerable to change federal Indian policy has been at certain periods in our history, and also because there is a legacy of this period, which we call the Termination period, that practitioners representing tribes or working in the Indian law area still have to deal with today throughout much of the United States. Now, the impetus for change in policy came in large part from the feelings that had been provoked, inspired by Collier's re-recognition of tribal inherent power and the value of tribal self-government, in those who thought that this was a move to resegregate tribes. There was a feeling in the part of these opponents that tribes had, or Indian peoples as individuals, had benefited from integrating into the economic structure, the political structure, the social structure of the United States, in large part, and that to recategorize them as a collective was to mark them as something apart. Now, this was a feeling that had arisen as early as the 1930s when Collier began the Indian Reorganization Act plan, but it received special impetus in the years of the Second World War, in which not only did many Native Americans participate, but in which Allied troops at the conclusion of the war came face to face with the horrors of the ethnic genocide that was a part of the Nazi program, directed particularly against the Jews. And so, coming back from the war in the mid-1940s, a number of members of Congress went on record as suggesting that this program that Collier had created of self-governing reservations looked a lot like what had happened in Germany, maybe what was happening in South Africa, with homelands being set aside for indigenous African peoples, and that this wasn't really the way that the United States should be going. Remember, the international political backdrop in the late 40s is the formation of the United Nations. The U.S. is pushing a heavy human rights agenda, individual human rights, and this notion of collective entities being created within the infrastructure or within the geographic limits of the United States was unsettling to some. And that gave a special reinforcement to this notion of opposition, sufficient to result in a change in federal policy in the late 1940s and early 1950s. It didn't last. By the end of the 1950s, it had sort of run its course, as we'll see when the Kennedy administration came in after the election of 1960. We're back to the Collier plan, essentially, and we're still there today. But it's important to realize that for this brief period, we did return to an opposite older course. And we're going to explore the salient features of that return in this and the next lecture. So there's a transitional statute. It's one that we've referred to before, and I think it's helpful to understand how it worked because it demonstrates how the same piece of legislation can be motivated by different concerns or different approaches to the making of Indian policy. And it's the Indian Claims Commission statute, the statute that created the Indian Claims Commission in 1946. Now, this was part of Collier's plan. Collier, you'll remember in the first version of the Indian Reorganization Act, had proposed creating a court of Indian rights that would have settled Indian claims. He and the Secretary of the Interior eventually decided that a commission, which is more informal body than a court, would work better. It's less adversarial. It's more a group of people listening to people talk about their issues, taking evidence on claims. And so this commission was created initially with 3, and then in the late 1960s it was expanded to 5 commissioners. And their jurisdiction was wide. Collier wanted tribes and individual tribal members to have an opportunity to raise these historic injustices and receive some form of compensation for them. So the jurisdiction allowed for claims in law or equity under the laws, treaties of the U.S. and executive orders of the President, claims which would result if the treaties, contracts, and agreements between the claimant and the United States were revised on the grounds of fraud, duress, unconscionable consideration, mutual or unilateral mistake, and claims based on fair and honorable dealings that are not recognized by any rule of law or equity. Now let me say a word about that. That first of those 3 categories of claim, those are legal claims. The second category of claims are legal claims that would have arisen if there had been fairness in the transaction. So the Army was there, we have a duress situation at the time of the negotiation, or we didn't understand what was happening. That's a unilateral mistake on the part of the tribes in a particular provision. So this jurisdictional grant says that the court can reimagine those deals. What would the deal have been if there hadn't been that mistake, or if the Army hadn't been there? And then the Commission's empowered to enforce that imagined deal, which is extraordinary. And the third of these, claims based on fair and honorable dealings that are not recognized by any rule or law or equity, this was the jurisdictional grant to consider what came to be called moral claims. Moral claims. So even if you don't have a legal claim in fact, or even if we can't reconstruct your agreement, your treaty, to give rise to a legal claim, if what happened simply wasn't right, then you can file a claim based on that too. And the Commission is empowered to award relief to you for that claim. There was no limitations period attached, either a statutory limitations period or an equitable limitations period, which is called latches, which is to say it doesn't matter how old these claims are, the moral claims or the legal claims or the hypothetical legal claims. If you were wronged by the United States, then this is your opportunity to come and say something. The form of relief was somewhat limited. The authorizing legislation said that the Commission is empowered to award cash. So this is what we call a legal remedy as opposed to an equitable remedy, which might include like you get your land back or something else happens. So cash compensation for wrongs. And the government is entitled to argue for, and the Commission is entitled to do this, to deduct amounts expended, this is the language of the statute, gratuitously for the benefit of the claimant. So if you have a moral claim against the U.S. and it's worth this much, but the U.S. can show that over the years they had provided this much to you outside of that relational context, then this amount gets subtracted from this before the amount is awarded. And lastly, the Indian Claims Commission jurisdictional statute allowed for the styling of some of these claims as takings claims under the Fifth Amendment to the Constitution, which is to say, we weren't just wronged here, but in fact, what the government did was to step in as sovereign and take our property for a public use, which the government can do. And in those instances, the Commission was directed to award not only damages for the original taking, for the original event, but interest from the date of the taking, which in many instances was enormous and far greater than the difference in value or the actual calculation of the damage, which is what was being awarded otherwise. Now, the Indian Claims Commission immediately flooded with claims. Hundreds of claims landed on the docket of these three commissioners, who eventually were expanded to 5, in part to deal with the caseload. Most of them were land claims based on the wrongful appropriation or unfair acquisition by the United States of Indian lands that had either been recognized as appertaining to that particular claimant through a treaty or a statute or something, and what were called aboriginal title lands, which is lands that belong to the claimants because of long historical occupancy, but where there hadn't been a treaty that recognized those lands or a statute as belonging in those dimensions with those boundaries to this particular claimant. Those are, you can think of those as sort of Johnson versus McIntosh lands, all those lands that suddenly became owned, the underlying title, by the discovering sovereign, where the tribe retained an occupancy right, but there isn't any piece of paper that says, and those are yours, and those are yours, and those are yours. So those are aboriginal title lands, and a lot of those had been, it was alleged in the Claims Commission proceedings, taken or appropriated or unfairly acquired in some other way by the United States, and compensation was sought for those. The Indian Claims Commission was intended to be fairly short-lived, but it had its termination date extended until eventually it persisted until 1978, when the Indian Claims Commission finally stopped operating. You'd get an award from the Commission. Either party could appeal that to the Court of Claims, and then from there you could go to the Supreme Court of the United States. That was the conventional path. And the total amount of awards, at least as of the mid-1980s, that the Claims Commission awarded was $818 million, which is a fair amount of money, and of course would be worth more today. Now, there were problems with the Claims Commission, and it's worth spending a minute on those. The first of these was the limitation on the relief that one could receive. A lot of tribes didn't want cash. They wanted their land back. And the most famous illustration of this is the claim that the various Sioux nations successfully brought for the Black Hills, a case that went to the Supreme Court of the United States. The tribes won and received a fairly hefty amount of money at the end of the day. They successfully argued that this was a taking. So they received compensation for the difference in value between what they received for the Black Hills and what they should have received, and interest on that. And the interest greatly exceeded the amount of the difference in value. But at the end of the day, with this award, they didn't want it. They didn't want the money. They never wanted the money. They wanted the Black Hills back. And so to this day, the money is sitting in an account, and the tribe is still waiting for some means to receive the physical ownership of the Black Hills, which had a spiritual connection for the tribe as well as a historical connection. The other problem, major problem, turned out to be the Supreme Court's unwillingness to allow compensation for the taking of aboriginal title lands, or to, stated differently, to recognize aboriginal title lands as property that qualified as property under the Fifth Amendment to the Constitution. Let me explain what I mean by that. The big case there is a 1955 decision. It's the Teton Indians versus the United States. What happened in the Teton case, this is an Alaska Native community, was that these folks were there. They had been on these lands for a long time. Their claimed aboriginal estate included water and timberlands and all sorts of stuff. And the Department of Agriculture showed up and started harvesting trees and wasn't planning on paying them for it. So they inquired and found a lawyer who evidently knew about the Shoshone case, which we talked about in an earlier lecture, which the Supreme Court said in 1938 that the occupancy right includes all the trees and the stuff that's under the ground. So they said this was a taking. This was the government coming in and taking their property, the trees, which attach to the occupancy right. The government's required to pay compensation for this. And they went through the Indian Claims Commission process. And the Supreme Court got it and said, they didn't say you're not entitled to anything. The only issue before the Supreme Court was, is this a taking? And in order to find that it was a taking, the court had to find, it decided, that the property right that was claimed by the tribe was a property right recognizable under the Fifth Amendment Takings Clause, which says that Congress shall not, or property, life, liberty, and property shall not be, or property shall not be taken for public purpose without just compensation. So is this property? Is this the sort of property that the government is forced to provide just compensation for under the Fifth Amendment? And the court eventually decided that it wasn't. The legal rationale was, well, if we find that it's property, then Congress is going to be obliged to compensate. But Congress shouldn't be forced to compensate for property that it hasn't recognized as property. Here, there's Supreme Court recognition, Johnson versus McIntosh, and this Aboriginal lands. Include rights enforceable against third parties, but Congress hasn't recognized this as property, and so we're not going to oblige them in the absence of a treaty or some other form of recognition to pay compensation when they take something attached to this occupancy right. Now, the underlying rationale appears to have been one the court's fairly open about. In footnote 17 of the opinion, the court notes, if Aboriginal title is compensable without special legislation, right, in addition to just the statute creating the Indian Claims Commission, to that effect, there were claims with estimated interest already pending before the Indian Claims Commission, aggregating $9 billion as of 1955. And what the court figured was, we'll bankrupt the United States if we allow all of these Aboriginal title claims to be considered takings, which means that we're going to have to calculate interest on them under the Indian Claims Commission Act from the date of the taking, then we're going to bankrupt the government. So we're not, the Supreme Court, we're not going to do that. So for those claims, you've got to get a special statute. Maybe Congress will, maybe they won't. It's a bit of a step back, if you will, to the old lone wolf rule that claims a breach of good faith are non-justiciable. You've got to go to Congress to solve it. And driven apparently in part by the Supreme Court's concern about imposing that hefty a load of liability on the federal government. Now, what's interesting about Teton and what's happened with the Indian Claims Commission is the way in which both of these moves reflect this change in policy that I alluded to at the beginning. Because Collier envisioned the Indian Claims Commission as a means of sort of furthering the restoration of tribal self-governments. We're going to encourage the creation of, or the reestablishment of tribal governance institutions, the creation of new governance institutions, economic development institutions, and we're going to fund them in part by allowing tribes cash recovery for past injustices, and then with that platform built and loans and federal encouragement, tribal governments can really become a permanent part of the landscape. But the way that it was sort of implemented after Collier left, and cases like the Teton case suggested that isn't what was happening at all. It started to feel like what Congress was doing was trying to wash its hands of the Indian problem, to sort of get rid of this Indian business once and for all. And then the new Commissioner of Indian Affairs stepped in and suggested that's exactly what Congress is going to do. 1947, the House and Senate Indian Affairs Committees were abolished. We're not going to need them anymore, was the implicit message. In the same year, the acting Commissioner of Indian Affairs appeared before the Senate Committee on Civil Services to testify about his vision of Indian policy, and what he suggested was that maybe it's time to get back to assimilation. Maybe it's time to step away from segregation. And so what I would propose, he says, is that we identify those tribes we believe to be most successful, most ready to integrate, or whose citizens are most ready to integrate into the national economy and political structure, and terminate their federal recognition as tribes. Terminate the federal tribal relationship and make those folks non-Indians as a matter of federal law. He suggested that the government start with the Osage, with the Klamath, and with the Menominee. And in 1953, Congress said, okay, that's what we're going to do. They passed a resolution called House Concurrent Resolution 108 that inaugurated the era that we're focusing on today, or this week, and that's the era that we call the Termination era, and the details of the policies of the legislative acts that resulted from the shift in policy will be the topic of our next lecture.